I'm Rebecca Lavoie, and this is the Readathon. And I'm here.
Since when do you start it like that?
Since I couldn't figure out how to start
Whenever
it.
you're not here.
Yeah, usually you're like, Kevin, guess what this is?
Yeah, when you're not here, though, I don't know what to do. So I just start it like I start every other podcast. So obviously Kevin's here and Mel is here. Kevin, do you want to say hi and introduce yourself?
Hi, Mel. I'm Kevin. I'm Rebecca's
No, I mean to the people. Say who you are and what you do.
The people who don't know me?
Yes. Just say hello. Say,
Hi.
I'm Kevin.
Hi, I'm Kevin.
I do this.
I do...
I host X.
I host These Are Their Stories, the Law and Order podcast.
Oh, Jesus. Was
and
that
I'm
hard?
also on... for fuck's sake. I don't introduce myself to everybody at Thanksgiving.
And would you like to introduce yourself, cooperative one?
I'll try to be really concise. So my name is Mel Barrett. I am the host of the In Between podcast, which is an investigative true crime podcast, and you can listen wherever you listen.
Now, Kevin.
Yeah.
I'm so glad we did not go to Dedham today.
Because it's raining.
Because not only is it cold and raining, but nothing happened except for some teasers.
A lot of good teasers, though. Yes, absolutely. So.
Yeah. So, Mel, obviously today we don't have a verdict, but there was some action.
Lots of action.
We got 4 questions from the jury, and weirdly, the 4th one was actually the first one, but it wasn't read in the right order, so they may be less confused than it would appear they're confused. But what did you think about the defense team in court today? Because we saw them a few times, and they were pretty active.
Yeah, a bunch of emotions all over the place. When the questions came in, it seemed that they were elated. That's the sense I got from what I was reading online, and then just the video that I saw. There was lots of hugging going on. Karen was talking to her family. Yannetti was joking around with Bev. They were like yucking it up. And then there were like thumbs up to the family. People were hugging. Karen was crying. Her family was crying. And I thought, okay, well, the questions that the jury has sent through is telling the defense that she's going to be found not guilty. Because that's the only response I could think of for that. You know?
Right. And they were huddled a lot. And there were a couple of hot mic moments. At one point, we heard Alan Jackson say to Alessi, Bob, I can't do that, or something like that.
Yeah.
Right?
No, he said, Bob, you got to do it. I can't do it.
Yeah. So
which I thought was really interesting.
Yeah. So he was writing something down, I think, preparing to say something to the judge. Let's talk about the questions themselves. So I'm actually going to put them in the order they were intended to be asked.
Because what we heard is the 4th question was actually the first question, or at least it wasn't the last question, right?
Yeah.
Can we just explain to the audience, though?
Yes.
We got 3 questions before lunch.
Yes.
And she held one of the questions until after lunch. And I don't understand why she did that.
I don't understand either. And what I'm wondering is if she made the assumption that Jackson did, which is that the other 3 answered the 4th. But also she said she couldn't answer the 4th because it was, quote, hypothetical because it started with the word if. So,
which is the definition of a hypothetical question.
Yeah.
It kind of felt like gameplay to me, though. Like, get all the questions done before lunch so the jury knows what they're doing. Go to lunch, come back, keep working.
Yeah. So what the 4th question was, which was actually sent in first, I wouldn't be crying and hugging my legal team if I got this question necessarily.
Right.
It was, if we can decide on 2 of the charges but not the 3rd, are we a hung jury? Is essentially the question. Kevin, if you heard that, wouldn't you think it was a manslaughter situation or something?
Well, I think Bev's answer is like, that's usually how I do it. In fact, I just might send you all home right now and not ask you anything.
Yeah.
But no, I think that you're right. I mean, isn't that how we interpret that? It's like saying we don't want to accidentally convict her of manslaughter because... firstly, it sounds
murder.
Yeah, the thing. Like, well, what if we did these other 2 and didn't do that? I mean, I think there's no other way to interpret that. It's like saying, well, maybe we actually will. That's what they're going to do.
Yeah,
those 2 big charges. So we're looking at the 2nd charge, which I believe is manslaughter as a result of operating under the influence. Or that's not exactly the word,
and then there's a bunch of sub-charges under
right,
that one.
Right. So, for example, you couldn't be charged with this if you were not drunk.
Yeah.
Right? So you say, okay, it's manslaughter, and then it's a different charge. Basically, they're saying our interpretation, this is the inference I have. The interpretation is for them, well, we believe she was drunk.
That's question 3, not question 4.
No, question 3 is leaving the scene of the accident.
No, question 3 that they sent in.
Oh, no, I'm sorry. I'm talking charge 2.
Yes.
My apologies here. So for charge number 2.
Yeah.
Is manslaughter as a result of operating on the influence. They're saying when they look at all the lesser charges, okay, yeah, we believe this much. We believe she was drunk while driving, but we don't believe it's manslaughter, so we can't do all of this. And I guess these sort of subcharges, these lesser charges, I guess we could check this one, but this is so fucking confusing that we're afraid we're signing up for an Apple App Store terms of service thing that's going to all of a sudden, screw this all up. That is their confusion. And there's about how you strictly interpret the law to communicate to them and what common sense is.
Yeah. So that was actually related to the third question they sent. The fourth question was, if we want to convict her on one thing but not on the other two, are we a hung jury? Question 3 was what you just addressed, Kevin, which is, does convicting her on a subcharge convict the overall charge?
Right.
So basically,
good question.
Yes.
Really good question.
Yeah, because that's obviously, you look at that jury form, it's like, yes, it's like guilty, not guilty, and then below it is a long list of guilty, 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 guilty. I could see reasonably interpreting that as if you check one of those boxes, the top one is guilty, right? Yeah.
Right, because it's either A or B or C or D, right?
Right.
So apparently...
And there was a typo. Did you hear the part about the typo?
No, go ahead, tell me that.
Well, Jackson was like, we want to correct one more thing. There's a typo. And she's like, oh, we already did it. And he was like, okay, but it should say or, not of.
Yes.
Yeah.
And it was like, it was specific
That's a big
to
deal.
It's an important little
big
word.
Deal.
Yeah.
Big deal.
Yeah. So essentially, I think what we got from this was that they're considering, it seems like they're considering the OUI charge, because when they said, does convicting guilty on a subcharge make the bigger charge guilty? And then they said, for example,
if by chance
charge 2 number 5 or whatever, and that happened to be the OUI one. but one of their other questions, Mel, which was super interesting, is what is the time frame for the OUI charge?
Super interesting.
Is it 12:45 or is it 5 a.m.? 12:45 is a funny time, by the way, because that's the time that Jen McCabe says that they were still outside. It's not the time they say the alleged collision happened, which is 12:32. Right. And then 5 a.m., of course, is when she's leaving John O'Keefe's house in her SUV. So what did you make of that question?
Well, I think it was a great question by the jury, and it shows how much they paid attention, because if it's 12:45, there's a lot of problems with 12:45. The main problem is that she's already at John's house at 12:36. So how could she have been driving at 12:45?
And there's that,
The other problem is if it's 5 a.m., you have no idea whether she's been drinking or not,
right?
Between 12:45 and 5 a.m. So the idea that they want to know, what OUI are you charging her with?
Yeah.
Like, when are you talking about, when was she supposedly driving?
Yeah.
I think it was a great question. And then I thought the answer was great too, which is, there is no time on the indictment, so I can't give them a time at all, which is what Bev said. But Hank Brennan gets up and he just throws the time out there. Well, we want it to say 12:45.
Yeah, I think that's a worse answer for them, honestly.
Yeah, it is, because they are discounting, and I don't know why. They've done it the whole trial. They're discounting that Wi-Fi connection time.
Yeah, it's not just that. They're discounting the fact that the test was done at 8 a.m. or whatever, 9 a.m. And that's hours and hours and hours after 12:45 in the morning.
He's only focused on 12:20 to 12:45, which is when they think the accident happened.
Right. And so by the way, the defense team wanted Cannoni to say, we can't tell you that. You have to decide. You're the fact finders.
Exactly. Yeah. Exactly.
Yeah. Their other question, Kevin, was, are video clips of Karen's interviews evidence, and how should we weigh them?
Well, I said early on that I thought this was a risk for her personally to give any statement. This is why you tell your client to just shut up and let me do the talking. She's very confident. But, I mean, when she talks about, I had this many drinks or whatever, this is what was happening, she counts out, how many drinks she has and refutes. I mean, she's basically giving testimony. Well, not in the literal sense, but she's telling the jurors the questions that they would answer. And I think she's telling on herself.
Yeah.
And, she's really incriminating herself. If this were just a drunk driving case with no personal injury, nothing like that, you should put that cassette in there and it's game over.
Yeah,
right?
So typically a first conviction for OUI Massachusetts does not include jail time, but it could be up to 2.5 years.
2 years.
Right. Yeah. But this is actually good. The question is, should we consider this evidence?
Yeah.
Is this testimony? Can we consider it? Is it just, which again was this whole other thing about why is the judge letting these random clips in with no other context?
Yeah.
No context. Yep.
Yeah. So essentially there was a big argument about this, right?
Yep.
Where Jackson wanted her to add the words "if any." So,
if any, which is the law.
Yes, give it the weight, if any, that you would give any other evidence.
Right.
And
really simple.
She didn't want to add that if any, and then Hank Brennan opposed the if any, so the if any didn't make it in, and he was very upset about it. And she's like, "Your objection is noted, Mr. Jackson." And that was one of two big fights they had today. So do you want to talk about sort of the contentious dialogue between Jackson and Cannoni today?
Jackson's ire is spilling over from last year. And I can't, so basically they went back and forth. I don't know why she's being so staunch about this. I heard some commentary today that really kind of interested me. And that is, they knew they had a problem with this jury slip in the last trial. Why wasn't this brought up months ago? Why didn't they start hashing this out months ago?
I know why.
At least to get ahead of it. Why?
Because there's a part in the process where you're supposed to do it. And that's because, and she kept putting things off. She kept saying, well, we'll do that when it's time. We'll do that when it's time.
But she's also like, well,
the Supreme Judicial Court said my slip was fine.
It's fine, so we're going to stick with it because she is not a judge. She's an agent of chaos.
But yeah, I thought that argument was really interesting because it was another example of Jackson really standing up for his client and speaking out and not taking no for an answer. And unfortunately, she does what she does. She was bevving all day. But I also was thinking about from the jury's perspective. And I was thinking, so there's 12 of them back there. One of those 12 people at least knows what happened in the last trial.
Yeah.
Right? So are there people on the jury in the jury room saying, listen, this is the same problem they had last year, and they found her not guilty on these two big charges. We can't make this same mistake, so we need to clarify this. And I wonder if those conversations are happening. And I am really frustrated with the fact that Bev might allow this to happen again, and it might result in another mistrial where they find her not guilty on the big charges and, they can't make a decision about this lesser charge.
Yeah.
If that's the case, I'm sure the Commonwealth is going to try her again. And this woman's already spent over $1 million. And this is getting to the point where it's unjust.
Yeah.
Unjust.
But I think that one of the problems, Mel, last time was that nobody seemed to know the real story, which is, oh, no, we're not deadlocked on all three.
Right.
No one had any idea that there was any movement on charges 1 and 3 or the other two, right?
Until after.
And I think not only were we sort of, burned once on this exact thing, but the jury is telegraphing, we're good on these two, but we're stuck here. And I can't imagine, like this time, if they come back with another no, we're really stuck, that A, she won't send them back, or B, that they're not going to inquire about, but wait a minute, Your Honor, can we pull them on the other two? So we don't, so they're not taken by surprise. But if anything from that first trial, anything from that first trial matches this second trial, it's not the witnesses they brought, it's this outcome. A confusing fucking jury slip, and it just messing up the way that these jurors think that they can communicate what their decision is.
The only thing I would say about it is that this goes in line with, I'm not changing my jury slip because the Supreme Judicial Court told me it was fine. And we're not changing the jury slip, Mr. Yannetti. You know better that all the jury slips are like this. That's what she said last time. So if they're like, we want you to poll the jury, and she goes, well, we don't poll juries in Massachusetts. Like, that's a big fear of mine. That's the way she rules.
Yes.
And what if she does it again where she's like, I don't have to talk to the jury. I don't have to ask them. We don't have to do that.
I have a new unifying theory about Judge Cannoni. Okay.
Oh boy.
So I've talked about, is it cognitive decline? Is it wanting just to spend time with her grandkids and like fuck everybody else? I have a third theory. I think she might be, this is a guess, that she might be a Luddite who actually doesn't pay a whole lot of attention to like stuff in the world, right? So she might genuinely think the Free Karen Read movement is bananas because she hasn't actually paid attention to the substance of it, just the look of it, right? And she is so literal. Like when they asked for the jury slip to say not guilty, guilty on all the charges, she said, bring me a case where that says that I have to do that. The Supreme Judicial Court said I was fine doing this. So she's just like, I literally need someone to tell me what to do. Apparently another judge came in today to talk to her about the verdict slip. I heard that
Really?
somebody reported that. Not 100% sure it's true, but somebody did report that. And I can imagine her just being like, no, this has always worked. It's fine. And just because all the people are outside doesn't change the way it's supposed to work. Like,
just because everyone's squawking in the buffer zone.
Very fixated. Oh, by the way, we just have to mention, we saw the crowds yesterday in person in Dedham. And it was, Kevin, was it not a scene?
It was a scene.
It's like
apparently it was a bigger scene today. Yeah.
Have you seen the videos? There's thousands of people there today.
Yeah. Well, Turtle Boy tweeted, everyone get to death.
Yes. And when Turtle Boy calls,
and he's like Aquaman for free care and read people.
This motion from Alan Jackson on the steps I thought was pretty amazing in that video you guys took. Yeah. I'm worried about Bev. I think you're right. I think that all three of those theories could exist in the same body that is Bev. And I think she's over it. She's tired. She wishes she didn't take this case on, but she did. And now she's stuck with it. And I do wish I wish another judge in Massachusetts would get on the phone and be like, this is a problem. You got to change this. Like,
I don't think judges would do that to each other.
Wait a minute. For district courts, and there are chief justices.
It was her. It was her before just last year. It was her.
but judges do have bosses, right? I mean, not bosses that say you have to do this, but people, that are hurting these cats. So can somebody say something to her besides an appellate court? Yes. But can they make her do something? No, they can't. But they can definitely say, hey, why don't you think about, instead of being so slavish to the what you think the law says, let's use some common sense here within the law and find the places where the law is silent and use this as a way to facilitate, some act. Otherwise, we're not doing justice here.
Yeah.
If we're setting something up that ends up being confusing, that jurors go the wrong way. Here's what I think is going on. I think that they are arguing about, they don't want to do this if it's going to be this. So in the end, they're not going to do this.
Not going to do OUI?
No, I think because if we do OUI, is she going to get manslaughter? And they're trying to find out. They're looking for the answer, yes or no. And if they get no answer, then their action is going to be to not charge on that because they don't want it. Because
they got an answer on that today. She walked them through the jury slip.
But you think all 12 people are crystal clear on what that means?
No.
There's going to be at least one person out of that 12 that says, never in a million years will I say. Will I take a chance without clear instructions? Will I say yes to OUI if I think that's going to happen?
Yeah. Is that what you think too, Mel? That's what's going to happen?
I actually agree. I agree with you, Kevin. I think that this jury is moving so much faster than the other jury. And it does seem to me that they are conscientious of the fact that if they make these decisions, this is a woman, she's going to go to prison for the rest of her life.
Yeah.
And that's why they're asking these questions on day 3, kind of like day 2.5. But that's why they're asking these questions. They're smart questions and they're thoughtful and they are trying to do the right thing, I think. And the idea that Bev will wait for them to ask a direct question and not a hypothetical before she gives them an answer is ludicrous.
Yeah.
The fact that the question started with if, and that's why she won't answer it. I'm like, this is ridiculous. I understand lawyers and judges, semantics, it happens, but this is a woman's life and the jury is asking deep, thoughtful questions and they're trying to do the right thing and she needs to guide them. That's her job.
So one of the observations I have about yesterday in Dedham is that talking to the field producer for the Vinnie Politan's show, she clearly either doesn't know if Karen redid it or sort of leans toward guilty because she's not really paying attention to the minutia of everything.
I think a lot of people at Court TV feel
and
that way.
she, by the way, I don't think Vinnie does. I think that
Vinnie
Vinnie
does
is, but I think that her thing is so many of the free Karen Read people we've talked to are bananas.
No, there's that.
So there's like a bananas aspect to them that she can't get the hurdle up. So because she said to me, she's like, it is so nice to have a reasonable, smart person with this point of view to have on the show. And I'm like, oh, you think the rest of them are... And she's like, you think the rest of them... I didn't say this, but I was like, my inference was she thinks the rest of them are are nuts. And so and I think that's how Bev thinks too. It's like all these nutty people like not going to work, taking like we heard people today saying that they were pretending to be sick at work so they could be at the courthouse yesterday. So
we met a woman who flew in by herself from Texas.
Yes.
Just to be there.
Not the only
She's here
one.
for the week,
but she was lovely.
Not the only one.
And we got recognized from TikTok.
We got our first TikTok recognition.
Wow.
Yeah.
Amazing.
Hi, everyone.
I sort of jump around channels. I'll check in with like the Law and Crime, and I'll check in with Court TV, and I'll check in with some of the lawyers like, Melanie Little, and I'll check in with 13th Juror. And I mean, Melanie Little and 13th Juror are sitting there live from 9 a.m. until the end of court every day. And Melanie Little has thousands of people watching with her. She's making
bank.
Long. People just sending her $20 just to ask her a question.
Yeah. Oh, we're doing it wrong, guys. We're doing it wrong.
Well, why can't the jurors do that? Bev, here's $20. Can you answer this in English? Somebody did a thing where they took they did it on X, and they took the slip and marked it and like kept check markings. And if you do this and if you do that, and it looked like the worst math exam paper
logic problem.
It's just it is a problem. Just because it fits the letter of the law doesn't mean it's coherent, and it's not coherent.
And other judges do it differently. That's something we know. But the judge has a discretion in Massachusetts.
How crazy is it that we can't agree, though, in a court of law, so as to not confuse the jury, to say charge one and then all these lesser charges under it? Guilty, not guilty. Right. Guilty, not guilty. All the way down the page.
It's so simple. It's such a simple solution.
I don't understand why we can't do this.
Well, I mean, a bigger question is like she was charged with 3 things. Yeah. So why is she
being subcharged?
Why can she then be charged? Why is she now defending herself against 15 things?
Well,
right?
The defense asked for that.
The defense, okay, well,
the defense wanted the OUI
to break it down, but like if you find
manslaughter and second degree, it's come on.
Homicide prosecutors will often charge with alternate theories of the case. So you will get a first degree and a second degree or whatever,
right?
Or a first degree, then a first degree with attention of, whatever, because they do want to cover their bases. But, is that exact?
So here's the thing I learned.
Yeah.
The definition of second degree and manslaughter in Massachusetts are actually not incompatible with each other.
Mm-hmm.
Because it's like the reasonable person can do something that results in someone's death. That is the manslaughter. Like if I back my car up, I know that that's a bad thing to do, and it could, and then if you die, even if I don't think that you're going to die, and then what the second degree is, they didn't plan to do it, but in the moment they did it. So they're not necessarily incompatible, because the manslaughter is almost like an attempted murder situation.
Yeah.
But it's just piling on, and it's like you didn't have a strong enough case to bring these.
Right. So we need to wrap. So I just want to ask everybody, I'll do a poll in the room. When do you think the verdict is going to come in? And if you think it's tomorrow, what time? And what do you think it's going to be? Mel, start with you.
I'm going to say tomorrow, and I'm going to say before lunch.
Mm-hmm.
Yeah, I'm with you there 100%.
And what do you think it's going to be?
I think it's going to be not guilty.
I
think she's going to be acquitted. I think that if they don't get an answer on the OUI, I think they're going to be like, well, that's another place, so you didn't prove it.
Yeah.
So
you think the same?
Yeah, I think the same. I think it's possible they may have one more question trying to figure this out.
How
one
much
last
jail
time
does an OUI get?
Well, they can't ask that question, right? They can't ask about the consequences of the thing. But again, if their question is essentially logistically, we're not sure
fuck do we
how
check
to fill out this form because you've made it the law so complicated, and you are supposed to be interpreting the law for us and instructing us. Again, I feel like if they can't figure it out between doing nothing versus doing something and getting it wrong, people will do nothing all the time.
I'm going to waffle. I'm going to say just before lunch or just after lunch. All right. Well, I know you've got baseball that you got to go.
Yeah.
And Mel, we are going to be talking, I know, all day tomorrow. Believe it or not, as you know, I canceled a meeting at 2 today because I was sure the verdict was going to come in. So now I have to have that meeting tomorrow morning. So I'm really hoping the verdict doesn't come in between 10 and 10:30 and 11:30. That's why I said maybe right after lunch, but it could. In which case, I'm going to say to my team, I need to go. We'll pick this up in 20 minutes.
I really expected them to stay. I expected the jury to be like, oh, we'll be done in like an hour. Just give us like another hour. Yeah. I was shocked when she was like, go home.
They're tired. They look tired. All right. Well, we'll talk tomorrow, everyone. Thanks so much for joining me on the Readathon.
Got it.
Thanks for having me.
partners in crime media.